Everybody. For those of you who don't know me, my name is John Edwards. I'm a judge at the Court of Appeal, and I'm also a student here at UL. I'm in the School of Law and I'm in the 6th year of a PhD. But it's my pleasure to come back to UL always, and I was particularly delighted to be invited to chair this evening's session. I have the easy job this evening in that all I have to do is say, I'm told, a few introductory words and introduce the speakers, and I'm absolutely delighted to do that. The background to the talk this evening is the Heneghan case, and as everybody I think probably knows, it arises out of the implications of the 7th Amendment to the Constitution, which in consequence of that, sections 6 and 7 of the relevant 1937 legislation, it's the Shannon Electoral, I've forgotten the exact name of the act, but in any event, the relevant 1937 act that provided for the Shannon electoral constituencies. Sections 6 and 7 of that were deemed, by virtue of the amendment in 1979, or 1997 was it, 1997, to be unconstitutional. And the person who brought the action is here with us this evening. It's Tomás Heneghan. It was an action initially commenced by judicial review, but was it was directed to be conducted ultimately as though it was an action commenced by plenary summons with witness evidence. And one of the witnesses in the case is here beside me, Laura Cahillane, who gave expert testimony. I think it was by affidavit, and you were cross-examined on it, is that right?
Very interesting experience.
Very interesting experience before the High Court concerning the historical context in which provision had been made in the 1937 Constitution for a Shannon, and also in regard to the circumstances in which it was sought to subsequently amend the Constitution. The action was heard in the High Court before a divisional High Court, which is an unusual beast. We don't see it very often. The High Court normally sits as a bench of one. A single High Court judge will hear most actions, but in cases that are regarded as being of exceptional importance or with very far-reaching implications, the President of the High Court has the power to convene what's known as a divisional court, which is a court of 3 High Court judges. And if memory serves me right, the divisional court in this instance was presided over by the then President of the High Court, Ms. Justice Irvine, with Mr. Justice O'Moore and
Mr. Justice Simons.
Mr. Justice Simons, correct. And the applicant or plaintiff, I think is probably the more correct title in circumstances where it was heard effectively as a plenary action. Tomás was unsuccessful in the High Court and appealed to the Supreme Court, and was ultimately successful in the Supreme Court. There were lots of nuances and complexities in the case, but essentially the case being made by Tomás was this, that the amendment effected by the 1997 referendum, which inserted a new Article 1842 into the Constitution, created a duty on the Oireachtas to enact appropriate legislation to give effect to what the people had mandated. The state's position, in contrast, was that it was permissive only, that what was authorised by the people empowered the Oireachtas, if they saw fit to do it, to make the necessary changes, but that they weren't obliged to do so. And ultimately the Supreme Court decided in favour of the plaintiff's or applicant's position, and found that Sections 6 and 7 of the 1937 Act, which would have been constitutional in terms of the Constitution as it was then, was no longer constitutional following the amendment effected by the referendum. And that's only in very, very brief outline what the case was about. There was a great deal in, particularly the judgment of Mr. Justice Murray, concerning the principles of constitutional interpretation. That was a really fascinating elucidation as to that. The differences between that and statutory interpretation. There are great similarities, but there are also very important differences. And another important feature which very much influenced him, certainly in arriving at his judgment, there were two other judgments, that of Mr. Justice Charlton and that of Mr. Justice Hogan. But certainly factors which influenced Mr. Justice Murray, or a factor which influenced Mr. Justice Murray, was the fact that at the time of promoting the referendum, the amendment in the referendum, the government had published literature which was sent to every potential voter on their polling card. I think there were posters in the polling stations, and the polling officers were even instructed in the case of blind or deaf or disabled people who might not, for one reason or other, be able to read this material that had been dropped through their letterbox, to actually read it or in some way draw it to the attention of the voter in question. And this literature made clear that the expectation was that legislation would be introduced to expand the franchise in terms of who could vote to elect a senator, a university senator, or a senator in the constituency in question, because the provision is for representatives from what were the two established universities in 1937, UCD and Trinity, but the new amendment makes provision for the franchise to be extended to other institutions of higher education. And the literature, as I say, that was promulgated made clear that certainly from the point of view of those organising the referendum, that the belief was that this was its purpose. It was sought to be argued after the fact, effectively, by those defending the action that Tomás brought, that in fact the whole point of it was to provide for what would happen should the NUI be dissolved. And that was a purpose or objective of the referendum, but it wasn't the only purpose. And yet the impression conveyed in the literature which had been promulgated very strongly emphasized, the literature very strongly emphasized and gave the impression that certainly a major part of what they were about was providing for enlargement of the franchise. And this was evidence which the Supreme Court felt it was proper to take into account in interpreting the effect of the amendment and in determining the issue as to whether, in fact, post the amendment articles, or rather sections 6 and 7 of the 1937 Act remained constitutional. So that's the background. The proposed running order, so to speak, is I think that Laura is going to introduce the main speakers and is going to perhaps give a more erudite account of what the case was about than I have just done but I'll invite her to speak now, and then we'll hear from our two contributors.
Thank you very much. I'll move over here for this part. So thank you very much to Mr. Justice Edwards for the introduction, and thank you very much also to Tomás and Eilís for being with us this evening. And I'm delighted that we're all gathered here today to celebrate what really is a momentous victory, and also to celebrate the bravery of Tomás in embarking on this journey in the first place. And I'm really looking forward to hearing him telling us all about this decision to take the challenge in the first place. And I think it's really important for us to reflect on how important this case actually is, both in a really practical sense in terms of what it means for UL graduates and graduates of other third level institutions who previously didn't have a vote in Shannon elections, but also in the wider context of Irish legal and constitutional history. So last week I started my lectures on the legislature with my second year constitutional law class, and every year when I get to this point, I have to explain to the students how the university franchise works. And I have to explain to them that purely as a matter of happenstance, that I have a vote in the Shannon elections because I graduated from UCC, but that when they graduate from UL, that they would not have a vote in the Shannon, and that there is no good reason for that difference. Because when our first constitution was drafted in 1922, it included a university graduate franchise. But it simply said, each university in the state shall be entitled to elect 3 representatives. And actually the franchise that time was to Dáil Éireann rather than to Shannon Éireann. But there was no naming of institutions. It was just a general idea that there would be a university franchise. And there's plenty of evidence, for example, that Queen's University in Belfast would have been included had Northern Ireland decided to opt into the Irish Free State. But the way our current constitution was drafted, the drafters were very much more prescriptive about things in general. And so it was decided to name the 2 institutions that were in existence at the time the Constitution was drafted. And they were the National University of Ireland and Trinity College. So they were the only 2 universities which existed. So that is why they were specifically named in the Constitution. And then the worst part of this story from the standpoint of the students is, again, I have to explain to them every year that in 1979, we held a referendum which gave the power to the Oireachtas to extend the franchise to all third level graduates. Now, as Mr. Justice Edwards alluded to there was a dual purpose in this referendum, and this became a key issue as part of the case. It was initially proposed on the idea that if the NUI were to break up, so the NUI was Cork, Galway and Dublin at the time, that we would need a constitutional amendment. But it quickly became about the extension of the franchise, and I might come back to that. But this amendment passed and clearly gave the power to the Oireachtas to extend that franchise to all third level graduates. So since 1979, it has been open to any government since then to bring forward the legislation that will extend that franchise. And so the reason that UL graduates and graduates of DCU and certain other institutions don't have the vote in the Shannon up until now is purely due to political inertia, and that nobody has actually gone ahead to pass the legislation, even though it's constitutionally allowed, and the court actually told us in the Supreme Court last year, constitutionally mandated, it turns out. But again, every year when I was teaching this, I would emphasise that this was clearly not what was intended when the Constitution was written, that you'd have such a distinction that certain university graduates would have a franchise and certain graduates would not. So it was never intended to be a limited franchise, limited to certain institutions. And as a joke, I would always say to students, if anyone is interested in taking a case on this, let me know. But one day, somebody did. And so when I got the call that Tomás was taking this case, I was delighted because I always felt there was a case to be made here. Now, the trickiest thing about this case is something Mr. Justice Edwards has already mentioned, and it's the language that was used in the amendment in 1979. Because the language that was used was that the Oireachtas may extend the franchise. And all the lawyers in the room know that when you use the word may, it's normally used to denote a discretion rather than an obligation. So it was a rather difficult legal argument to make that the state had an obligation to legislate to give effect to that vote in 1979. Normally, we would expect the language to be more mandatory if there was an obligation. You'd expect the wording shall. That's what we'd normally see when we would expect an obligation to be expressed. So because of that hurdle, the case initially failed in the High Court. Now, I was disappointed by the High Court judgment for a number of different reasons, and I'm not going to go into all of them tonight. I think that's an article waiting to be written. But I think there was some very disappointing reasoning given by the High Court. And I'll just give one or two examples, because there was a line right at the end of the High Court judgment that really bothered me, where the High Court said that the Constitution prefers graduates of TCD and NUI, which of course is completely historically inaccurate and makes very little sense. It wasn't that a value judgment had been made to say that graduates from these two particular institutions were inherently more suitable to vote in Shannon elections than any other particular institution. So I felt it was a rather maybe distasteful remark, as well as being inaccurate, of course. But there were also some rather unusual statements made in that judgment. For example, the judgment asked that if the people had intended that the franchise would be extended, then why was the original Article 18 left untouched? But of course, the answer to that, and something Mr. Justice Murray did answer in the Supreme Court judgment as well, is that the people in a referendum are completely dependent on the government to bring forward a suitable amendment to them. And once a proposal is put before the people in the form of a referendum question, a constitutional amendment, the people don't have the power to say to the government, no, that's badly phrased, go back and do it again. The people only have the choice to either accept it and vote for it or reject it. So again, I think some rather strange comments being made in the High Court. So even for that comment alone about graduates being preferred, I was delighted that Flack and Tomás decided ultimately to appeal the case to the Supreme Court. And when the case was appealed, I think lots of people felt that the case had very little chance of succeeding, particularly because of that may-must language argument. It's easy to say in hindsight, I always had a feeling that we would have a better chance before the Supreme Court than before the High Court. But even I was very surprised the morning the judgment came down to see that all of the judges, all bar one, had agreed. Only one judge had dissented, Mr. Justice Charlton, but even Mr. Justice Charlton only dissented on the form of order to be made. So ultimately all the judges agreed, all 7 agreed, that this situation was unconstitutional, which was pretty incredible. Now, this Supreme Court judgment is hugely important for a number of different reasons. First, obviously, a declaration was made that the current situation is unconstitutional, that the Oireachtas was required to legislate to implement that decision that had been made by the people in 1979 to extend the franchise to all third-level graduates. And obviously, this is a huge change. It's going to be something that will be very difficult to implement in practice, and there are lots of decisions yet to be made on how all of this is going to be done. But from a democratic perspective, I think it sends a really important message that there are no second-class citizens. All third-level graduates are equal, and they all have a voice in electing members of our upper house of Parliament. And I think that's hugely important. The judgment is also really significant from a constitutional perspective because it has set down new precedent on how we interpret our constitution. and how we interpret constitutional amendments and how these are different from the way we interpret the original text of the Constitution. The judgment also made some important comments on when extrinsic evidence can be taken into account in terms of constitutional interpretation and what type of evidence, and the fact that expert evidence isn't always very helpful on this point, particularly where there's competing evidence on the issues, which there was in this case. But even though the Supreme Court made that point, that the expert evidence isn't always useful, ultimately the case turned, if I may say so, on evidence which had been presented as part of the expert report on behalf of Tomás, which was the explanatory statement that Mr. Justice Edwards has referred to. This explanatory statement, which had been included on the ballot paper and displayed in all of the polling stations, basically blew the state's argument out of the water, because the state was trying to argue that the entire purpose of the referendum was the breakup of the NUI, and it wasn't really about the extension of the franchise. And yet, this explanatory statement, which was read out to everybody, made it clear that actually the key issue was the extension of the franchise. It may have started out as being a referendum about the breakup of the NUI, but it's very clear when you look at the newspaper coverage at the time, you listen to the Dáil debates where the politicians spoke about what would be done when this franchise was extended, how the new franchise would work, and all of that evidence is there to show that this was all about extension of the franchise. And that's clearly what the people were listening to and were talking about and reading on the ballot paper. So that is what they believed they were voting for in 1979. So once Mr. Justice Murray identified that this extension of the franchise issue was a key part of that 1979 referendum, the next question was whether the Oireachtas was required to legislate in order to give effect to the decision that the people had made. And Mr. Justice Murray reasons through all of this in a very sophisticated but yet very logical way. And he demonstrates how the word may is not always used in a discretionary sense. And in fact, in this particular context, it makes no sense to use it in a discretionary way. And so in the end, he decides that there always was a duty to carry out the clear intent of the people in voting for that constitutional amendment. Now, there are many more fascinating aspects to this case. We could be here all evening talking about it. Mr. Justice Hogan gives another really fascinating concurring judgment where, like Mr. Justice Murray, he's very critical of the wording of the amendment. There's a great line where he says, in legal terms, it was the equivalent of the attempted cleaning of an old master by a careless restoration artist who then proceeded to leave an ink stain on a Rembrandt. But I think there are very important lessons in there for us for the future in terms of how we deal with constitutional amendments in the future. Now, I was a little bit disappointed with how the courts dealt with the equality argument, but again, I think that's an issue for another day, and certainly the Supreme Court are going to be looking at it again very soon. And none of that takes away, obviously, from the immensity of the victory in having the current system struck down as unconstitutional. And I think this case is a good example of what the Supreme Court can now do now that it has become more of a constitutional court. It's not held back in the same way as, for example, the Court of Appeal is in having to deal with lots of appeals on very technical issues. The Supreme Court can choose what it hears, and it has much more time available to it, so that it can give this time to these major constitutional issues involving things like rights, democracy, the institutions of state, the separation of powers, how our institutions function. So these issues are being given the proper consideration that they deserve, and the Supreme Court is producing truly sophisticated and transformative judgments as a result. Of course, from a UL perspective, this case now means that our graduates are on a par with graduates from the NUI and Trinity College and any other third level graduate, because anyone with a third level degree will now have a right to vote as part of this franchise. Of course, the other thing is that this is not going to be an easy task to establish or to accomplish, because the court has given the government until 2025 to do all of this. but it doesn't seem like there's any plan yet in place as to how this is all going to be done. It also seems there may be a battle in terms of relinquishing some of the existing seats. So in one way, perhaps a happy consequence of this might be that it might actually force the government's hand in implementing more extensive reform than just looking at those university seats. Because this is an institution that everybody knows and it's been accepted for a long time is in need of significant reform. But like the university franchise issue itself, there's never been a political appetite to make the necessary changes. So perhaps by forcing this particular change and the fact that it's going to be difficult to accomplish in isolation, it may lead to much greater change. And that would be an even bigger legacy for Tomás Heneghan, who has achieved what many lawyers said was impossible with this case. And on that note, I'm going to hand you over to Tomás and let him tell you all about his incredible journey, which has led to us being here tonight.
Sorry, just setting a timer. Right, so I have half an hour. So, trying to read off my notes too much. There we go. Breaking the inertia, I have stolen Dr. Cahillane's phrase. So when Dr. Cahillane first suggested this event, I went back and forth on the different ways I could start this speech. But ultimately, I decided the best way was to just repeat what I said to Sinead Lucy, who is the managing solicitor at FLAC, when we first met back in January 2020, I think. She asked me why I was taking the case, and I could have made some grand statement about the rule of law or the importance of democracy, and both of those I truly believe in. But instead, I just spoke from the heart. I told her that in the run-up to my 18th birthday, many years ago now, unfortunately, I only really cared about two different things. One, becoming a blood donor. Two, registering to vote for elections. Now, the first one is a story for another day, so I'm not going to hijack this event with it. The second one, I was focused on Dáil elections and referendums, and that was fine, registered to vote. But as the years moved on, as I came closer to graduation in UL, I started to wonder why I didn't have a vote in Shannon elections. So the more I thought about it, I realized it was just unfair. But of course, unfairness isn't a great legal challenge. So in April 2019, I had actually gone into the High Court by myself as a lay litigant and had sought leave to bring a judicial review against the Irish Blood Transfusion Service and the Minister for Health over the rules on blood donation. I had been successful. The judge was very complimentary of my pleadings. I thought I was fantastic. So I decided that I would just translate the two things over. So I had this one successful application for leave, so I could easily just replicate that. It doesn't work that way. So the seed started to grow, and I was riding on this high from this first win. I convinced myself that I could replicate it, and that's where Heneghan and Minister for Housing, Planning and Local Government started. So I started Googling, as you do, and I was looking for something that would give me a strong basis, a strong case that I could go ahead with, and up popped this article from RTE, from Dr. Laura Cahillane, who I had heard of before, but unfortunately never had as a lecturer while I was here. So I read it with interest, and I pulled out these two quotes. And the one that stood out most to me was, while there are a plethora of other aspects of the Seanad equally in need of reform, these may be a long time coming. None are so easily accomplished as solving the university's equality issue. However, like everything else, with regard to the Seanad, it seems there is simply no political will. And there it was. The university seats. That was the key. So I obsessed over this case for weeks and months. And one morning I was walking to work, my 9-to-5 job, thinking away. Probably need to do less of that, maybe. And I remembered back to my time here in UL. I was doing my final year project in, I think, maybe 2013. Dr. Emer Spain, I'm not sure if she's still here, was my supervisor. She was very patient with me. Too patient, I think. But it was on abortion law, specifically the X case. So I decided to do my FYP on the compatibility of the Protection of Life During Pregnancy Act 2013, as it was then, with the judgment in the X case. And I remembered there was a line in the judgment, but it was years ago, so I didn't know it, and I wasn't sure if I was imagining it, maybe. So when I got home from work that evening, I Googled it really quickly, and I had to read through the whole judgment, trying to find this one line that I didn't know whether it existed or not, and then I found it. In the context of the 8 years that have passed since the amendment, that's the 8th Amendment in 1983, the failure by the legislature to enact the appropriate legislation is no longer just unfortunate, it is inexcusable. So I had a starting point. The Supreme Court specifically had said, you've previously failed to enact a piece of legislation following the referendum, and it wasn't good enough. So next I started reading cases, and I didn't have access to a legal database, so I just started Googling again, and Google Scholar was my best friend for a few months. I checked words like democracy, voting, equality, referendums, any word, any combination of words. I came up with the Doherty case, so that's Pierce Doherty. I found Jordan, which is, I think it was a 2015 challenge or 2013 challenge to the children's rights referendum. I found the Robbie Sinnott case, which involves voting for blind people. And Godzall, which is one that people may not have heard of. That's Gillian Godzall. She ran for, I think, European elections, maybe 2014. And she had been excluded from running as a candidate, so she challenged that. So all these cases, I was reading them on trains, on buses, in my spare time. That's all I was doing. I started to pull this argument together. But then I had to look at the Constitution, obviously. So I looked at these two articles. They're pretty clear. Sovereignty and democracy. Sorry. And I started to wonder to myself, how could we have this part of a foundational legal document of the state that talked about sovereignty and the importance of the will of the people, but yet we had this referendum from 1979 that has never been enacted. And not only that, some of the people chose the legislature, the Seanad, not all of the people. So that seemed like a contradiction to me, so I ran with it. That's just the 7th Amendment. I'm going to leave that up for a bit. So, did I ever believe, way back then in 2019, that I would find myself in the Supreme Court with this one? No. No, I did not. And I'll tell you why. A general election was due by 2021, but it was an unstable supply or confidence in supply arrangement, so everyone knew that it would probably end in 2020. So I felt like I was pushing on an open door. I thought, this is fantastic. I'm going to bring this case and I'm going to signal to all the political parties that this needs to be on their agenda. And that's all I will have to do. That's not how it went. So the election came and went, and it was not included in the programme for government, but I won't go down too far that route, because I want to take it back to actually September 2019. And something else that happened that shored up my arguments, or well, I thought it did, and it wasn't even in this country. So I was visiting London for a couple of days. It was actually trying to donate blood there. Again, story for another day. And the political world in the UK was shaking at the time because the Prime Minister, Boris Johnson, was attempting to have Parliament suspended, essentially to avoid arguments about his Brexit deal. So that went to the Supreme Court in the UK, and they released this. Now, I'm not going to read out the whole thing. It's very wordy, sorry. But essentially what jumped out to me was this one line where they said, laws enacted by the Crown in Parliament are supreme form of law in our legal system, which everyone, including the government, must comply. Now, obviously, we don't have a crown, but the Parliament here, the Oireachtas, takes its authority from the people. The people are sovereign. And the people had said in 1979, expand the Seanad electorate. Arguably, in 2013, they had also implicitly said expand the Seanad franchise, but we will not go into that one. So on a Monday morning in mid-September 2019, I showed up to the High Court with maybe an hour and a half, 2 hours sleep, and one can of Monster inside me. I had 2 assignments due at King's Inns that morning, so I had stayed up all night working on those and making sure this case looked okay. So I went in, I thought I would just make my arguments and walk out 5 minutes later because Seamus Noonan, the judge from back in April that year, was so complimentary of my pleadings, so surely he would just say, yep, no problem, off you go. Seamus Noonan had been appointed to the Court of Appeal in the interim and I had not been paying attention. So I walked in and I thought, who is this man? This is not part of the plan. But I thought, it's fine, I'm confident in my legal arguments, I'm going to make them, I'm getting leave and I'll walk out here and it's going to be fantastic. That did not happen. I was told to put the respondents on notice and to come back in February. So I left the court feeling tired and deflated, but still determined. I decided I would serve the papers on the other side and just enjoy Christmas. As the weeks passed though, I kept checking courts.ie looking for an update, but there was nothing past December on the case. And I kept thinking, but the judge said come back in February. Why is there nothing on the system? So my friend that I worked with said, call the registrar. Just email her, find out what's going on. So I did. She told me actually, the judge had made an order. The order was that he wasn't giving leave and to come back in February. That was the order. That's when I realized that I could not run this case myself because of these technicalities that I was just not aware of. So I approached PILA, which is the Public Interest Law Alliance. I was aware of their work from various different things. I had engaged with FLAC before on different issues. And I asked them if they would be interested in taking up this case. They told me that they deal with organizations rather than individuals, but they would put me in touch with FLAC. So they did. A couple of weeks passed. I gave them my pleadings. They came up with an opinion. And in January 2020, I went up to the FLAC office in Dublin and I met Sinead Lucy, the managing solicitor. And I think that was the best decision I ever made. There was a wobble at the time where I thought, should I be doing this? But no, I was determined. And then the global pandemic came and everything got paused. Everything. But the court hearing finally did arrive, and as is already mentioned, it was before a divisional court, so 3 judges, including the president. And I thought, this is fantastic. If the president is sitting in on this, she must think it has merit. So we had an unusual hearing in that it was by video link, which was still relatively new back then. So it wasn't the first case, but it was still new. There were technical glitches. My camera on my laptop didn't work, so I got to sit there in my pajamas. No, I didn't. That's a joke. I actually did suit up. I had bought a UL tie, thinking I would be wearing it into court. So I sat in my chair in my bedroom wearing a UL tie and a UL face mask, just to prove the point. No one could see me. However, and again, this has already been mentioned, it was not the most enjoyable experience, and I personally felt from pretty much the start, or the first 10 minutes of the first day, it was a 2-day hearing, I felt we had lost it pretty early. And to be honest, it was a painful experience to watch, and my camera was off, so I didn't even have to react. And honestly, I feel like, Laura, you probably feel the same. Yeah. I'm going to be honest here. For months after that case, I felt a lot of guilt over getting Dr. Cahillane even involved, but I'm not going to go into that. it happened and we move on. So when the judgment dropped in November, the outcome wasn't obviously a massive shock, but the strength and reality of it was a blow. No matter how much you prepare, it still hits you in the gut. So when I opened the judgment in the email, I skipped right to the bottom. I didn't care about the reasoning. I just wanted to see the answer. And I was left disappointed. And I stood in my sitting room. My housemates were away for a month, I think, in France. Lucky them. I stood in my kitchen just crying. It was not dignified. It was horrible. Lunchtime hit, and I walked across the Liffey to a cafe nearby to get a coffee, and it was all on autopilot. I just followed my normal path. I didn't deviate. It was almost raining, so Shakespeare would have loved that one. And the low mood continued for a good while afterwards, particularly when I saw some commentators online practically celebrating the outcome. I thought, whatever your feelings about the Seanad, arguments we had made, how could you celebrate people being denied access to democracy? How could you celebrate that? So that did not help my mood. When I first brought legal proceedings back in 2015 on the blood donation thing, and I hate bringing it back to this, but it was the starting point, I quickly had to get used to the fact that it was going to be a lonely and occasionally upsetting journey. And that only increased this court judgment. No matter how big your legal team, no matter how many friends and family members you surround yourself with, when you're a litigant in these scenarios, you are by yourself. You can have a room full of people, but you are responsible for the outcome. You have to own it. So that was difficult. The day after the judgment dropped, I had already previously organized to meet a senator and some of her staff to record a video calling for an end to the blood donation ban at the time. The same day, the Taoiseach, Micheál Martin at the time, was giving his first address to the Seanad. And I felt like this was a cruel twist of fate. I listened in, I sat in Costa Coffee and watched it, and I thought, this is horrible. I really don't want to engage in this anymore. And this is where I could lie to you all and tell you I knew from that moment we would go straight to the Supreme Court, determined. But that's not what happened. I certainly let it be known publicly that I intended to continue fine. But my heart probably wasn't fully in it at that point. It was a painful rejection from the High Court, and I did not want to repeat it in a higher court for a longer period of time with 7 judges instead of 3. So, you probably can't see that picture. I'll explain in a second. That's the judgment from the High Court that Laura referenced. And one particular line of it about preference for NUI and TCD. So that weekend, it rained because it was November, and I sat in a cafe called Music Cafe on Wellington Quay in Dublin, and again, you can see it there, across at the Four Courts Dome, so it's lovely setting. And it was the first time I'd read the judgment, so I'd waited 3 or 4 days before I would even read the thing. I just didn't want to. So I started reading through it. I had a yellow highlighter. The picture that I faded into the background is from that. I took a picture for posterity, so there's a little yellow highlighter there. And I went through it line by line, and I tried to find something that would motivate me, because I wasn't motivated. And that's when I spotted the preference thing, and immediately alarm bells rang, and I thought, oh my God, have they just annulled the 7th Amendment here? Could someone, so if the Oireachtas brought forward legislation to expand the franchise, could a Trinity graduate go, well, actually, this court judgment says I'm preferred in the Constitution, so none of that, thank you. So I started to get really concerned. I thought, oh my God, not only have I failed, I've actually made it worse. It's like when you pick on a scab. And that's when I decided, sitting in that cafe, I decided, actually, no, I have to keep doing this. I broke it, I gotta fix it now. Or at least try. So this is the potentially controversial part. So, I'll get back to that quote in a second. But there was a costs hearing, because there always is. And the state wanted its costs from me, because of course they did. But it wasn't a shock. They had flagged this earlier to me that this would happen if I lost. So you can read it there yourselves. I don't want to read it. But they were essentially inviting me to withdraw the case in the space of 7 days. Or they would pursue me for costs if I lost. And I went back within minutes to Sinead Lucy, probably too hastily. And as you can see there, I reject the state's respondent's invitation. I should have taken a breath before I sent that one. I reject their invitation in the letter and confirm that I have no intention of withdrawing the proceedings. The state respondents have had opportunities over the last 40 plus years to correct this violation of constitutional rights, and they have failed to do so. And in my view, it's correctly a matter for the courts now. As an aside, very quickly, that quote there is from the renowned journalist Justin McCarthy, who wrote a over-the-top piece, I think, about the case after it was over in the Supreme Court, in which she said the state threw the kitchen sink and all silver spoons at him. That article is now in Justine's new book, which people should buy, because it's fantastic. And Justine, just to mention, was an adjunct professor here in journalism when I was studying journalism here, so a fun roundabout there. But it didn't end there. Again, in December, so before the High Court hearing, a second offer was made. Drop the case in 7 days, and we will forget all of this happened. Again, it was quite a shorter response. I've read the correspondence and can confirm again that I have no intention of withdrawing the proceedings. The problem with me is when I get an idea in my head, I'm going to run with it. And my family say that so I say determined. They say stubborn to a fault. So my issue during the costs hearing was I had lost, fair enough. But why was the state looking for costs when the state represents the people? Were they saying that the people to withhold access to the Seanad electorate from the people? That made no sense to me. So wasn't a fan. Now, thankfully, the judges saw the public interest aspect of it and made no order for costs. However, that did leave me feeling guilty that my side had lost out as well. Now, it obviously wasn't the purpose of them coming on board and representing me, but you still feel guilty. You still, even, every page that was photocopied costs something. So, I'm going to jump forward to, yes. So the appeal was lodged. The court accepted the appeal in June 2022, and across 2 days in October that year, I sat at the back of the Supreme Court and listened. There was no clear indication across either day which side was going to win. It went back and forth and back and forth, but the judges engaged, which was the most important part. Then we came to the may versus shall argument that had plagued the High Court hearing. It was a rabbit hole we had ended up down very quickly, and the minute it was mentioned in the Supreme Court, I sat back in the seat and went, not this again, can't deal with this. But it was our saving grace, because they identified something that I had missed all along. The first part of the article in question says shall, and the amendment didn't change that. So the only way to read that article is if you change the first shall to may. And if you change the first shall to may, you can change the may in the second part to shall. And that's effectively what happened. But none of us knew after the 2 days how it would actually go, and we had a long wait for the judgment. 5:42 p.m. It was a Tuesday evening near the end of March, and I was lying on my bed at home just after work. I was waiting to go to the gym at 6 p.m. and Sinead emailed me to tell me the judgment will be dropping on Friday. I've been checking the court website every evening for updates and it wasn't there. So I couldn't quite believe it, but I let myself lean in a small bit. So I told a few friends, and on the way home from rugby training the following evening, I phoned my dad. He doesn't do texts, and I told him what was going on. He had been consistently worried for years that all of my legal gallivanting would end me up in a lot of trouble, particularly with money. So I was trying to reassure him that no matter what happened, it would be fine. And I also thought maybe it could end up on RTE, and he watches RTE News. So I just want to let him know, just in case, that it might happen. So that was fine. There was something else that happened that week. So the previous Friday, the Seanad schedule, and I am a nerd, so I subscribe to the Oireachtas newsletters that come out every Friday evening. I got this Seanad schedule, and it said that a bill from a Fianna Fáil senator to do with the university franchise was due to be discussed on Thursday, March 30th. So I thought, that's great, I'll go in and watch that debate. I asked my manager, they said, yep, no problem, have your annual leave. So I contacted Senator Alice Mary Higgins, and I asked her, could she sponsor me to go in and watch it that Thursday? And she told me, bear in mind this was the Monday, that it had been removed from the schedule, and no one knew why. I just thought that was strange. But obviously within a few days, we knew why, because the Supreme Court was about to decide on it. So I told my manager that I needed to switch the days. That was no problem. I had Friday off. I got my suit ready. I got my UL tie ready. I got my little pins ready. Everything was great except for the weather. It was March and it lashed rain. It's so unfair. So I tried to write 2 statements that night. One celebrating a win and one addressing a loss. But I couldn't. All I could think of was, at least I tried. That was it. That was my statement. So it was raining that Friday. I arrived at the Four Courts Lewis stop early and sat in a cafe called Good Cafe. So it's G-U-U-D. It's a really weird spelling. Drank a latte, read a book. And if anyone's wondering, it's Juno Loves Legs. It's a really fantastic novel. You should all read it. So I sat there for an hour just reading it. But again, autopilot. Nothing was going in. I was just reading words. About 11 o'clock, I went over to the court. I met Sinead and the rest of the team outside the courtroom. We went in, we sat down, they had a conversation, I sat waiting. At 3 minutes past, and I checked this because I thought, whatever way this goes, it's going to be historic. So 3 minutes past 11, the judges came in their robes and they all sat down and everybody else sat down too. And we waited. Within minutes, the stir began. It was clear we had won. Chris, who is FLAC's legal officer and a fantastic individual, he left the room to spread the word. Obviously, it's not good to have your phone out in the Supreme Court. I sat there staring ahead. I had sort of an out-of-body experience because I could see myself looking absolutely terrified, and I will be honest, I was scared. I'd won, but I was scared. And to this day, 7 months later, I don't know why. I genuinely don't know why I was scared. So everything else moved really fast that day. I drank a lot of coffee. Went to the gym to try and clear my head. And that night, even though it was lashing rain, and I didn't want to do it, I have made plans with a friend from work to go watch a rugby match in UCD. I decided I needed to be around people, socializing. And so I went into town, got the bus with him, and again, another wonderful twist of fate. It was the UCD versus Trinity colours match that they have every year. I had just destroyed their monopoly on the Seanad, so I had no preference who was going to win that match. I I didn't care. They both lost that day to me. I really enjoyed the evening. It was lashing rain. I got soaked. Trinity lost. I enjoyed that too. But that was the perfect ending to that day. I don't know why. It just was. So, what next? I'll be honest. When I saw the title for this event, I thought slightly disagrees with my position. So I want to vote in Shannon elections. I will not ever lie about that. And if I get the vote next month, I will absolutely use it. But I don't want it just for me. At Christmas, I'm going to be sitting at my family table with the whole family, cousins and everything. And even if I get a vote in Shannon elections, it'll be maybe 1/6 of my family will be allowed to vote. The rest will still not have a vote. It's not right. It's not fair. So where are we now? So the Taoiseach, recently enough, gave a speech in the Seanad and pretty much dismissed the idea of any type of reform. Damn, I'm over half an hour. I'll be very quick. So he dismissed pretty much any type of reform. Then on the 3rd of October, the relevant minister basically indicated that there is a bill being drafted at the moment, and the name would certainly suggest it's going to expand it to the universities, or the other universities, but doesn't look like it's going to go any further. Like I said, that's not where I want it to be. So, for anyone that doesn't know, there is currently a bill sitting before the Seanad, this one. It's quite a meaty one. I have not read it all, I'll be honest. I've read the key points. And it's called the Seanad Bill, and it's 2020. So it was introduced shortly after the last election, and it was paused from November 2020 and has not been returned to. The bill, if enacted, would give everyone a vote for 28 senators. 15 senators would continue to be elected as they currently are by councillors, TDs, and outgoing senators. And of course, third-level institutions, all of them across the state, would enjoy a vote on the 6. So that's going to sit there. We don't know what's going to happen with it. There doesn't seem to be a plan. But the one thing I would say, I want people to look at the Bacik case from 2020. In that, it was made very clear that the Seanad cannot meet unless it has all 60 members. Now, in my mind, someone could hypothetically run on the university panels and challenge the outcome. They could, on the basis of this Supreme Court judgment. And the problem with that is it would freeze the Oireachtas based on the Bacik judgment. So that's not what we want to see happen. So, sorry, trying to find my place. So the key thing for me is that everyone gets a vote. This was never just about me getting to vote. It was never just about UL graduates. That was the key to break the inertia. Before I do my thanks to everyone, and there's a good few of them, I have to mention a somber aspect to tonight that I couldn't avoid mentioning. So yes, I'm a graduate of the School of Law. Technically, I think it was a joint honours in psychology and criminal justice, so I'm not sure who gave me my degree. But I was also a journalism student here. I did my postgrad, my master's here, and I dragged it out far too long. And the thing about journalism here is that it's a very small community. There's a small batch of students that work together, particularly on the likes of the Limerick Voice. So I wanted to express my condolences to the students, the staff, the friends of Joe Drennan, who recently passed away. I'm conscious that it would be wrong for me to come here tonight and pretend that that isn't something that recently happened. Like I mentioned, the journalism school is a small community. So, yeah. So now I will do my thanks to people. So firstly, I want to thank Dr. Cahillane, obviously, not just for this event, but for giving evidence in the case and for writing about this issue for so long and sharing her views. It sparked the case essentially at the start. And I also want to thank, obviously, Mr. Justice John Edwards for chairing. I want to thank Eilís Barry for being here and for her incredible support throughout this entire process. And I think Eilís was actually the second person I hugged that day of the Supreme Court thing, so that was nice. I want to thank the incredible staff at the School of Law and at the university across the board. This place was my home for 6+ years. I started in September 2010. I was not the best student, but people were patient with me, thankfully. I also want to thank, the university itself. This place, and I've said it numerous times to people tonight, this place is incredible. It is a beautiful campus. The Living Bridge is just, well, it's everything really. I came here as a shy, extremely awkward young adult at the age of 18. And I feel like I grew up here into a slightly less socially awkward, fully grown adult. Oh my gosh, I think I reached the end. Yeah, okay, sorry, thank you.
I'm Eilís Barry from the Free Legal Advice Centres, and I'm absolutely delighted to be here in the University of Limerick to celebrate Tomás' achievement. And it was such a great idea, Laura, so thank you very much for inviting me here and having this event for Tomás. I always associate this building in particular with Micheál O'Sullivan. I'm probably showing my age, but he was a much loved, very inspiring person. I narrowly missed out on being born in Limerick. My dad was from Thomond Gate, and he'd be tickled pink to think I'm actually here speaking here. So thanks again to Laura for inviting me. FLAC is one of Ireland's oldest civil societies. It's been campaigning for access to justice for over 50 years now, with the twin aims of providing legal assistance to people who can't afford it and campaigning for a comprehensive scheme of civil legal aid. So we're really pleased that our campaign to have the current system of civil legal aid reviewed was successful, and we're really pleased that, to be participating in the review of our current scheme that's going on. So what do we mean by access to justice? I'm sure Laura would have a very legal meaning to give to it, but in FLAC we see it as a continuum starting with access to legal information, access to legal advice and advocacy. Now, obviously, Tomás didn't need any of that, which I think is quite revealing. The next part of the continuum is access to legal representation, whether by legal aid or getting a private solicitor and hoping for some form of no full, no fee arrangement. Our current legal aid system is extremely restrictive. It operates a very strict means test. Tomás, as an employee, I think would probably fail the current means test. It also excludes cases that are taken on behalf of groups of people. So if Tomás had brought the case on behalf of all of the graduates of the University of Limerick, he wouldn't have been entitled to legal aid. It also largely by effect excludes test cases, that is, cases that may have an impact beyond the individual, even though the legislation isn't clear in that regard. There's also a merits test. If Tomás had applied for legal aid, he would have had to satisfy the Legal Aid Board that his case was reasonably likely to succeed. Now, given the ranks of people who almost queued up to tell us that the case wouldn't succeed, that in fact it was political and would be seen as not a kind of bona fide use of the law, I think he probably would have failed the merits test if he'd applied for legal aid. And I think it's for that reason I'm very thankful to our legal team that was led by Rosario Boyle, who was always confident about the case from the outset. And I have to mention the barristers James Kane, Emma Sinnott and Davy Lawler, and a huge thanks to Laura herself, who gave a huge contribution to the case, and as Tomás said, I think was the inspiration for the case in the first instance. Access to justice doesn't stop with someone getting legal aid or legal representation. It also involves access to the courts and what happens in the court. And as Tomás said, he started off as a lay litigant and felt he had to get advice once he had to amend his proceedings. Now, our information line, we operate a telephone information line where people can ring and get basic legal information. We regularly hear from people who are absolutely struggling with complex court cases, who haven't got legal aid or representation, and they need some form of advice as to how to navigate the court system, and it just isn't there, and FLAC doesn't have the resources to fill that gap. So the modernisation of the courts, which has been led by Angela Denning, the Chief Executive of the Court Services, is really welcome. The Kelly Review on the Administration of Justice recommended a complete overhaul of our court's rules and procedures, and that's also really welcome and really overdue. But the recommendation in the review, which was carried out by the former President of the High Court, actually makes a recommendation which puts an onus on a potential applicant to articulate their case in detail when the rules of procedures are amended. And I often feel, and I think we in FLAC feel, that our court system is predicated on the notion that a client will be represented by a lawyer, and I think that works its way through into the courts, into the rules and procedures that govern proceedings. A colleague from another organisation recently sent me a statutory instrument that covers procedures for recovering debt, and he pointed out to me that it was likely that the plaintiff was likely to be a large multinational financial service, and the defendant was likely to be someone in extreme debt who obviously wouldn't be represented. And he had counted the words in one sentence had a staggering 187 words in it, and he pointed out to me that it had 24 commas. So how even, now I'm not going to read it to you, but I read it to myself last night. It took me a minute and a half to read one sentence, and it's literally that long. How someone, I couldn't understand it as a lawyer, and how I think it'd be completely impenetrable for the layperson trying to defend themselves. The plaintiff may be trying to recover their family home. So I hope when the rules are being changed and modernised and made simpler, that the likes of Tomás, who has acted as a lay litigant, will be consulted. So what happens once the proceedings have started off is also important, and particularly when there isn't a real equality of arms. And I welcome the guidelines that have been issued recently by the Attorney General in relation to the state, and the principles are very timely. But these principles are intended to act as guidelines for the state in maintaining high standards of ethics and integrity in the conduct of litigation. And it's to be hoped that they will be a positive example to other litigants. But I think the guidelines don't cover a number of issues which I'd just like to touch on, which FLAC regularly encounters with public bodies. We would regularly correspond with local authorities on behalf of claimants who really don't want to end up in court. And very often we don't get any answer whatsoever to numerous letters and numerous correspondence. These would be coming from, they'd be legal letters, and there'd be no response. And the plaintiff who does not want to bring the case has no option, if they're to try and proceed to get what they're entitled to, but to start proceedings. And very often, as soon as the proceedings start, the respondent, who might be a public body, will immediately then try and settle the case, which is a terrible waste of everyone's time, including the court time. And I would love that would be specifically dealt with in the guidelines. We're also very aware that public bodies will try and insist on very strict non-disclosure agreements where often if a case is settled, the parties will agree that they won't reveal to anyone what how much compensation was paid in a particular case, and that's quite understandable. But what a number of public bodies do is they insist that the fact of the settlement is also kept confidential. And that means that the lawyers can't go and say to their colleagues who may have been sitting with them in the High Court when they got leave to apply, actually that case settled. They can't say anything about it at all. And I find that hard to see how a public body can engage in that sort of behaviour, and that it's in the public interest. So just to, I suppose, consider why is access to justice, or FLAC's version of access to justice, so important. Obviously, it's very important for the individual who may have rights that they need to enforce. We also know on a more macro level that access to justice improves social inclusion. We had a conference on legal aid earlier this year, and we had commentators for England highlighting research that shows that access to justice actually improves health outcomes. And we heard about a doctor in England who was treating very seriously people with very serious illnesses, releasing them out into accommodation that was very poor. They were failing to get better. They were ending up back in hospital for long periods of time, being released out again, not getting better back in hospital. He eventually got them legal advice. They got their social welfare benefits. They got better housing. They got better, and they stopped having to be admitted into hospital. So I suppose it's a no-brainer in some ways to see a link between access to justice and health outcomes. But what we're talking about here tonight is the link between access to justice and democracy and the rule of law. If laws are enacted and they then aren't enforced, that leads to a deficit in democracy. And at the heart of access to justice, from FLAC's perspective, is holding powerful bodies and the state to account. And Tomás has done that magnificently, I think, in his particular case. Just to say a little bit about FLAC and how we end up representing claimants like Tomás. We run a telephone information line where approximately 12,000 people a year get legal advice. We also run legal advice clinics where lawyers acting pro bono provide legal advice. We make policy and law reform recommendations in areas of law that most impact on people who experience poverty, disadvantage, discrimination and exclusion. And we also run the public interest law PILA, which Tomás referenced, which links NGOs with lawyers who will act for the NGO pro bono. We also operate an independent law centre, and Tomás has referenced Sinead, who is our managing solicitor, who would really like to have been here tonight and sends her best wishes. And as the Independent Law Centre, we operate a legal service for the traveller community, we operate a legal service for the Roma community, and most recently have opened up a legal service for the LGBTIQ+ community. Now, on top of that, and we're quite a small organisation with very little resources, we try and bring a small number of cases in what we call is the public interest. We don't define what the public interest is, but we mean cases that will have an impact beyond the individual. Now, very often we call it strategic litigation, or academics like Jerry White will call it strategic litigation, but very often the reality is that we will end up representing people that no one else will represent, and that the case won't get taken if FLAC doesn't actually provide representation. And I'll just give you a number of examples. We acted for a Down syndrome man who wanted to marry his Down syndrome partner, and the care home where he was living instituted proceedings against him to have him made a ward of court when they discovered he was going to get married. And he came to us saying, "What can I do? I want to marry my girlfriend." And it ended up having to challenge the wardship jurisdiction, and ended up the legislation was brought forward to amend the very outdated wardship legislation. It started as a man wanting to get married, and it ended up as a case that had huge impact. So when we talk about strategic litigation, it usually starts with someone who feels they've been treated really badly. You can't tell in advance when something is going to be strategic or not. Robbie We also acted for 20 years for Lydia Foy, instituting 3 sets of proceedings until she finally, after 20 years, got her birth cert in the gender of her choice, and we ended up with gender recognition legislation, and the world hasn't collapsed, despite what a lot of commentators in the UK would lead you to believe. One case that went through Pila was the Robbie Sinnott case. Robbie was a blind activist who wanted to exercise his right to a secret ballot. And when he voted, he either had to rely on a friend or the returning officer to read out the list of candidates to him, and then he would say who he wanted to vote for, and they'd mark the X against the relevant candidates. He felt that was a huge breach of his privacy, which it clearly was, but he was also concerned that he had no way of checking if the returning officer or his friend accurately reflected his wishes. So he brought a very successful High Court challenge and was successful in that. I think it takes enormous courage, resilience and grit to act as a plaintiff, particularly when you're acting against the state and the power and resources that the state has. We're always complaining that the state doesn't spend enough money on legal aid. However, when the state is a litigant, there seems to be no end to the resources it pours into defending a case, and that can lead to a real inequality of arms. Tomás acted for himself at the initial stages until the procedures got too complex, and we were very happy to represent him after that. Our managing solicitor, Sinead Lucy, who is not effusive, and it's a complete understatement to say she's not effusive. She was clearly really impressed by Tomás and fought very hard to represent him. We had to go to flat counsel because it was going to involve a huge amount of time and resources to get our governing board to agree that Tomás would be represented. And she said at the time that it was an honour to represent him. And I was very struck and moved by Tomás's motivation for the case. There was no financial gain waiting for Tomás at the end of the case, and he could have faced a possibly ruinous order for costs. And he told me, he has said it again here, that he brought the case as his dad didn't go to college. And that really resonated to me because my parents didn't go to college either. They would have stopped school at 13 or 15, which was what happened to people of that generation. And I was really horrified in court when one of the judges kind of questioned Tomás's bona fides and said, well, actually, this case isn't about equality. It isn't about the equality guarantee. You just want to join one of the elites. And I thought that was actually really unfair. It took enormous bravery and courage for Tomás to take this case. If ever there was a public interest case which has an impact beyond the individual, I think this case has to be one of them. I let Laura and others, I'm not an academic, talk about the impact of the case, but it's clearly about equality and democracy. It'll clearly mean a broader franchise, but it's also about, and I think this is what's really interesting, because it's kind of the unexpected outcome of it, that the courts will have to give effect to the will of the people as expressed in a referendum. And that has to have implications beyond just this particular referendum. Like, I think immediately of the children's rights referendum, which has proved to be very disappointing. We've 4,000 children at the moment who are homeless. And you have to think, does that fact give expression to the will of the people when they voted for the children's rights referendum? I attended a lecture just last week where the eminent Supreme Court Judge Gerard Hogan was talking about the grunge norm of the Constitution. Now, I sat through the lecture. I didn't know what the grunge norm was at the beginning, and I have to say I didn't know what the grunge norm was at the end. I was sitting beside a High Court judge who also said she didn't know either. So, but apparently the Heneghan judgment shows what the grunge norm of the Constitution is, Tomás. I thought you'd like to know that. I think it means that it's about that it expresses the will of the people. I think it has something to do. Laura can put me right on that. Sinead says I turn into Irish mammy mode when I'm around Tomás, and I have to say I had huge concerns about the day of the judgment and was really worried if there was an order of costs made against him. And I remember him, He said he was terrified. He looked terrified the day of the judgment. He was standing in court, physically shaking, and I thought, oh my God, what is going to be the outcome? But Sinead was right. It was an absolute honour for FLAC to represent him. We're really proud to have represented him. And to revert to being an Irish mammy, because I am an Irish mammy and a granny, my adult children regularly give out to me for the state of the world that they're inheriting from our generation. And when you see our environment and rapid climate change and what's happening in Ukraine and the calamitous, horrifying events in the Middle East, you have to kind of say, yeah, there's some truth to their complaint. But when I see Tomás and what he stands for and what he does, and his energy and his motivation and his passion and his idealism, I can't help but feel there's some faint hope for all of us in the future. So I just want to say thank you, Tomás, and what you've done for equality and democracy in Ireland.
We're running just a little bit over, so we have time for a few questions, but maybe just 5 or 10 minutes. Would anybody like to ask any of the speakers anything arising out of the presentations? Speaking for myself, I found it fascinating.
Damien's waiting patiently with the microphone.
Yeah, I look as though I'm going to say.
Well, I might kick it off. If nobody's going to ask a question, I'll abuse my position on the stage. Because we were kind of talking about this earlier, and I know your quest may not be entirely complete on this issue, but when you think about the major constitutional law cases, the cases that have had such a huge impact on Irish law and Irish constitutional law, you think about the names like Crotty, McKenna, and Heneghan is now on that list of these major constitutional law cases. Has that actually sunk in with you that like you're in the legal history books now?
No. No, like I spent like 4 years here studying law and trying to remember case names and obsessing over the big ones like Crotty, and actually McKenna is like a bugbear of mine because at the time when I was studying it, I thought, why she agreed. I want to make sure this is the right one. This is the referendum spending.
Yes.
Yes. So clearly I didn't learn that much. But I remember thinking at the time, like, why is she challenging this? She agrees with the divorce, with what was being proposed. Why is she challenging this? And I think now I get it. So I absolutely adore most of the half of the six university senators. And like you have names like Catherine McGuinness, you obviously have Mary Robinson, you have these fantastic people that I hugely admire. And I think now I get it. Like, I wasn't attacking them, I wasn't attacking their position, I wasn't saying you are doing so badly that we need more voters in to get rid of people like you. That wasn't it. I may agree with them, I may disagree with other university senators, but that doesn't matter. What matters is that people get to decide. And I think the McKenna case was like that. It wasn't necessarily about whether you agree with the substantive point or not. It was, do you think this wider point is right or wrong?
Fairness in the process.
Yeah, that's it.
Yeah. Very admirable. Does anyone else want to ask a question before we leave it there? There's one over there.
Hello. Hi. Yeah. Hi. Yeah. Okay. It is a bit off topic, but I think like most of the success stories these days, it revolves around the same thing that you rightly mentioned, that you did look at social media and you were very upset about those comments and everything. So I think for most of us, it is the same thing. And what is so upsetting about that is you don't even know those people, and they are just randomly commenting. So in your situation, how did you think about this? How did you take those home, and did you just completely went offline, or what it was? How did you react to those?
Particularly the tweets, I drafted many tweets in response and just put them in the saved folder and never sent them. That was the only way I could deal with it, because it was just, weirdly enough, while some of it was kind of nasty, there were people that I hugely admired, because I'm kind of a nerd when it comes to the law. So there were people I was following on Twitter that I really admired. And they were saying things like, good for him, but it's hopeless. I was like, why are you breaking my heart? But yeah, like, I just drafted responses and never sent them, because it was the only, like, I had to get it out. You have to get it out, but better not to hit send is a lesson for sure.
So, Lucianne Buckley, and the new head of the School of Law here at UL, and this is not a question, it's just a comment, really, that thank you all so much, but thank you also, Tomás, particularly. I think when we study law, we often don't realise what's going on behind the scenes. We hear about a particular case, there might be particular facts that raise our sympathy or whatever, but we don't realise the human cost and the effort and the persistence and the struggle that goes behind bringing a case of this kind. And I don't know, I think we probably have law students here. I think that's a really important lesson for all of us, but also for our law students to take forward, that this is not something that is easy. And Eilís, you've mentioned, the issue of access to justice and the struggle for that. But a huge commendation and thank you for the work that FLAC does in this space. But I think it is really important for us all to realise just how difficult this is, and to appreciate how much effort and persistence and difficulty goes into something of this kind. So thank you all, and my colleague Laura, for your contribution to this really important victory for democracy as well. So often we are accused of living in an ivory tower, and it just goes to show that constitutional law clearly here has a very strong practical relevance and consequence, and it's really great to see reaching out into the community and supporting democracy in this very practical way. So just thank you all, but particularly Tomás, for illustrating the humanity behind what goes into a legal case of this kind. So thank you.
I would just say, actually, and this was a point that was in my head coming down here on the train today, when I was a student here, I remember hearing all those names of cases, and sometimes there was a photo with it, and you could go, oh yeah, that was such and such a person, and they took this case, and you focus in academia on the case and the outcome and all the meanings it has, and that's great. And I did that when I was here. I used to think a case was just, or the name was just the name of a case. It wasn't the name of a person. It was just the name of a case. And I've learned the hard way that that's not the reality, that it's, no matter what the case is, even if it is a technicality, if it's a planning case or something, there's always a person on the other end, and no matter the outcome, if they end up losing, there's always going to be heartbreak involved. Regardless of what the issue is, it's rejection, and rejection is horrible, especially when it comes from the courts, especially when you think you were right. So yeah, I just think, I think that's something that FLAC does a really great job of. When they represent clients, they project the human, the person, that it's not just a name of a case. And they were great with that with me. I don't want to talk about any other cases because live cases, but they're with other people, they are also making sure that the humanity of the plaintiff is there and visible, because otherwise it just becomes a name. And one thing that happened, and it wasn't this one, it was when I started that case, someone messaged me and went, oh, if I knew it was that easy, I would have done it a few years ago. taking the case. I remember throwing my phone across the room, being like, it wasn't easy. Actually, on that note, I know it isn't related to the comment, but there is going to be a blood donation clinic in Castle Troy on the 20th and 21st. If anyone is eligible, please do consider becoming a blood donor. Sorry, I needed to hijack the event.
I'd like to just add, I was a solicitor and I did a lot of work with legal aid as well, and I can understand how difficult it is in bringing a case like this, and I know the emotion that's involved, and part of my job, and your job, Eilís, is to help people through this emotional journey that you've been on. And I spoke to you outside, and I said to you, congratulations, and you said, oh, it's all the lawyers, they did it. No, I think you should really recognise that what you've done is a remarkable achievement. And I, on behalf of, I'd like to say on behalf of my fellow students here, would like to congratulate you and wish you well for the future. And, well, hopefully we won't see you in the courts, though.
Thank you. Thanks.
Very good. Well, I think we've just about run out of time, so I'd like to thank everybody who's contributed this evening. It really was a fascinating presentation, series of presentations, and everybody is to be congratulated for their role in it. So, well done.
Thanks.